Okay, here's a question, ID 30803. It says, what can I expect after I am charged with theft? It's a good question. I recently got a theft of goods charge at a local store. I have nothing on my record. The cost of everything was $67.10. I was given a misdemeanor summons. I was wondering what the outlook on this will be. Will I have to worry about jail time? I will take care of any fines I am given. Will I have to take a drug test when I am summoned? Will this go on my record? Well, that's a lot of questions. Let's sort of deal with them in order here. All right, you've been charged with theft in the third degree. It's a gross misdemeanor. Your worst case scenario is a judge could give you up to 365 days in jail. I've never seen it happen on a first offense. You're probably not likely, at least in Pierce County, where I practice, you're not likely to go to jail for any time at all. If you were convicted of theft in the third degree, you would be assessed fines, and it varies by jurisdiction. And court costs, you're probably looking at anywhere between a couple $100 and $500 in most courts for a misdemeanor conviction for theft in the third degree. You have some options, though. Depending on who the alleged victim is, there's a thing called a compromise of misdemeanor, which can frequently be used to get charges dismissed against you, to get the case kicked out. It basically involves making an offer of compromise to the alleged victim in this matter and paying restitution. The restitution, even if the person or the store or the entity got all the stuff back, there's still restitution. And this restitution is basically a fine that you would pay to the store owner or the victim in this matter, the alleged victim. And it can be anywhere from, I had one recently, the guy just wanted $20 for food that my client dined and dashed on. Sometimes stores ask for a couple $100. If you pay the restitution and the store accepts the restitution, then what we typically do is we fill out something that says that, I, the store owner, declare that I've been made whole by this, and I have civil remedies, and I don't want to see any criminal prosecution in this matter, and I'd like to see charges dismissed. The prosecutor sometimes objects, sometimes they don't. More often than not, and it's very rare, I've never had a judge decline to approve this kind of settlement. The judge will then dismiss charges and say that the victim or alleged victim has been made whole, and the case goes away. It would still show that you've been charged with a crime, but that the charge was dismissed, and that's it. It will go on your record to the extent that it shows that you were at one time charged with this crime. Again, but it shows as a dismissal. After a couple of years of law-abiding behavior, you could actually get that dismissal expunged, which means that if somebody wanted to look you up, they wouldn't be able to, and they wouldn't see that in there. Let's see. Will I have to take a drug test when I am summoned? I haven't seen that. I haven't seen that here in Pierce County or King County or Thurston County. The judges ordered a drug test on a theft case. I guess in theory it could happen if you were placed on probation and ordered to go down and perform a UA. If there were some facts in the case, if they found drugs or drug paraphernalia on you at the time that you were stopped for allegedly stealing this guy's stuff or the store's stuff, then I guess in theory a judge could order you to take a UA, urinalysis, to determine whether or not you have drugs in your system. But based on sort of the sparse facts you've given me, I don't see that happening. If you were convicted of theft in the third degree, yeah, it would go on your record. It would show as a conviction for theft. It's a crime of dishonesty. If you were to get in trouble later on, really over the next 10 years, that crime of dishonesty could be used against you if you were to testify in a trial. So it would show on your record. On the other hand, if you cleaned your record up, or I'm getting ahead of myself, if you were to pay off all the fines, pay off the restitution, stay out of trouble for a couple of years, then you can do a motion to vacate, which means that you can go back to the court where you were convicted and you would tell them, I want to vacate this record, I've stayed out of trouble, this isn't a crime of violence, it's not a crime against a person, and I'm allowed to clean this off of my record. What the judge would do is he would vacate the guilty finding and then dismiss the underlying action, and your history would be cleaned up. So you have some options, but your best bet is go find an attorney, talk to that attorney. We don't charge to talk to people. If you called us up, we'd set up an interview with you. You can come down and talk to us. If you want to do it over the telephone, you can do that. We never charge for these things, and we'd let you know a little bit more. And I'd have more questions for you. Who's the alleged victim? What kind of stuff was taken? Stuff like that. And we can give you a little more information then and let you know how we can help you. So, but it's a great question. Thanks for asking.